I gave you a number of lawful bases, including consent, including aspects to do with if it's a matter of national security, if you have to perform a contract and it's a legal obligation that you have to do, then that is a lawful base that you can use to collect or process personal data. Then, of course, the other principle being minimality. The principle of minimality speaks to the fact that you need to only collect or process personal data that is relevant for a particular purpose. So let's say if you have to analyze information about maybe a WASH program that has been implemented by your organization, and you're collecting and analyzing and processing different personal data of the different maybe participants or beneficiaries of this program. Why would you, for example, collect their political affiliations? Right now we're in a political season. Why would you need to collect, which party they subscribe to and the kind? That may not be relevant for you being able to analyze the success or the implementation status of a particular project that you're working on. So you should only be in position to collect and process relevant or minimal information for a particular purpose that you're dealing with. Then, of course, the other principle being the principle of retention. And this speaks to the fact that you should only retain information for a particular period of time that is lawful. And if you don't need that information anymore, then you should ideally be in position to get rid of it. So, of course, the law does not expressly provide for what retention periods one must have. But first and foremost, in the principle of accountability, one of the things we expect you to have is a data protection policy. And within this policy, this is an internal document that speaks to your data processing activities as an organization. Within that, we expect aspects to do with what retention periods you have as an entity in terms of adhering to these particular principles. But even better, as an office, we are coming up with guidelines that will be in position to speak to the retention periods that can be implemented by particular sectors. Let's say if you're an NGO or if you're government, you may have different sets of personal data that you may need for different purposes. So the retention periods may vary, but those guidelines will be in position to point you to the right direction on what retention periods you should be in position to look at. This should be ready sometime next year, and I believe we'll go ahead to share the same with you. Then, of course, the principle of quality. This principle of quality speaks to the fact that you need to have accurate information or up-to-date information. If you're collecting and processing personal data, how do you go ahead to ensure that it's actually up to date? How often do you review it in terms of analyzing the same? That's a principle that we have within the Act. Then, of course, the other principle being the principle of transparency. Transparency speaks to the fact that you need to inform data subjects. You've already dealt with who data subjects are. You need to inform them on how you're going to collect or process their data. For example, if you're going to be doing M&E work and you have to maybe work with partners that may not be in the country, that may be outside Uganda, to do that analysis, data subjects should be, or participants that you work with should be informed of that particular kind of activity. That yes, we have collected your data, but for the purposes of analyzing the same, we may share this data to, let's say, company ABC for this particular purpose. And this is a key principle of transparency. It's how transparent you're being with them. So that at the point of them giving consent, they give what we call the informed consent that we talked about when we're defining what amounts to consent, that they're giving this consent from an informed point of view when they know who may have access to the data, whom it may be shared with, and the kind. Then, of course, lastly, the principle of security. Now, this principle speaks to the fact that you need to have adequate security measures to protect the kind of personal data that you collect or process as you go about your duties. And this stems right from both the physical security, which may include things like cabinets. Maybe you may have particular uh, boxes or whichever where you store the kind of personal data that you collect. But also speaks to information security, where you may have, let's say, you store data on a cloud, or you have a particular systems that you use to collect and process data and even analyze the same. There's need to have security measures in place to protect this information. Maybe you have passwords or you have firewalls in place to ensure that the data you collect is actually secure from cyber attacks, from breaches, and the kind. Now, we are going to look at how we can integrate this information within the kind of work that we do as M&E professionals. So as you handle the different information, you maybe have particular information that has been brought before you. You have, let's say, consent forms. There's need to ensure that this information is actually secured. As an organization, as an NGO, there is need to ensure that you have a data protection and privacy policy in place. Yes, you may have policies on other issues, let's say human resource, acceptable use, communication, but there's need to have independent policies on data protection and privacy so that people are able to understand, employees understand their obligations in terms of protecting the information that you work with. And of course, appointing a data protection officer. So this accountability, as we process information before us, the different personal data, be responsible for the same and ensure that there's always a clear chain of responsibility of data. Because at any one point in the chain of data across the different life cycle within the organization, this data can be breached at any one of those points. So that's why there's need to ensure that as an entity, you work collectively together to ensure that data is actually secured. Then, of course, the other principles being lawful and transparent processing. And this speaks to, for example, if it's an NGO based in Uganda, evaluating the impact of a livelihood project in Ngulu, you must be in position to inform the different beneficiaries why their data is being collected, and not just telling people maybe sign here and there, and that's just it. You need to inform them and have a lawful basis that you rely on to actually collect or process this information. And of course, in terms of transparency, you need to inform them on how this data will be used, where it may be stored, and of course, used includes things like even the analysis, which can include profiling. For example, if you want to find out maybe in the if you're trying to find out, let's say, the project or a livelihood project that you've implemented, you're trying to maybe analyze what age groups, participated the most or benefited the most from this particular program. They should be ideally informed of what and how their data may be used or analyzed. And this fulfills this particular principle of transparency that we talked about as one of the principles of data protection. Then, of course, the other principle being the one of data minimization, that you should only request or record personal data that you actually need. If you're going to analyze data as M&E, you may not need particular information, particular personal data, again, like I mentioned, political affiliation. If you're implementing a youth skilling program, you may not need someone's religion or their tribe. Of course, unless this directly relates to the different evaluation indicators that you have to look at. But other than that, then that may not be necessary information or relevant information for us to do our analysis and evaluation of a particular project. Then when it comes to the quality of data, for this, there's need to double check and ensure that you check for the accuracy of information. And for this, for example, if it's a baseline survey of a WASH program in Karamoja, and the different data sets that are collected, including names, age, and location, these need to be verified to ensure that errors are, for example, reduced. So let's say if you're collecting someone's name, you may need to maybe verify with their ID to ensure that they can actually be identified and confirm that indeed this is the person that we are working with. All these are intended to ensure that you adhere to the principle of quality. before you, for example, do an analysis of information, do what we call data cleaning. You sort of, sieve this data to ensure it is actually accurate and correct, to remove any inconsistencies. And where you find that there are some errors made, of course, being in position to provide avenues for the different participants to correct and rectify the same before you can go ahead and analyze this kind of data. So that is how best we can actually enforce and integrate this principle within the kind of work that we do. Then, of course, the principle of retention. I talked about the fact that you need to come up with, or have, for those that already have these policies, the data protection and privacy policies that actually speak to the retention period. Because, for example, you may find that as M&E, you may need personal data to analyze throughout the entire project until the project comes to an end, or even after, maybe for follow-up activities. But then you would find that, let's say, another department, like let's say HR, that has shortlisted candidates for a particular role. Why are they still retaining information of the unsuccessful candidates? Let's say 1 year later, why are they still having that kind of information? Because the more information you have, the higher the risks of this information being breached or exposed to unauthorized third parties. So if you have clear retention periods or guidelines within these policies, then there's need to ensure that these actually adhere to. And where a project is complete, you can go ahead and either archive this data or delete it, depending on what policy you have, to minimize any unauthorized access of this information. Then, of course, the other being the principle of security and how this can be implemented. The fact that you do not need to disclose if you have information before you to analyze, you don't need to disclose it to any unauthorized individuals. They may either be within the organization or even outside the organization. There's a need to ensure that this data before you is actually protected. So you can use, for example, strong passwords, which should ideally also be changed quite frequently. I know that personally, for example, when I was still in school, I had one password for almost everything. The password to the student email, password to my personal email, password to my phone, the password to my account, and to anything else that required a password. I had one password, but this is not a good password policy. It's until later on I realized that actually there was need to ensure that, my data is secured, because if someone gets not just that password, it means they can access everything or any other information about you on the different platforms that, you use. So that's why there's need to ensure that, these passwords are changed frequently. Again, this is something that maybe parents may relate with quite often. For many of the parents, you find that all your children have access to your phone. They know your phone password. They know the password for your laptop and your gadgets. And yet you may find that some of these actually have personal data that ideally should not be shared with any third parties. You may even have information about work on some of these gadgets that could ideally still be in the hands of these children of ours, who are also, by the way, potential criminals, because they could also use that data for other purposes. So ensuring that, you change passwords quite frequently and use very strong passwords as you collect and process this information go a long way. And of course, not taking screenshots of some of this data. In the recent past, these days when the president appoints someone to a public office, before this person actually is aware of the same, a number of people on social media are already aware, and you're already aware and discussing their capabilities or lack thereof to be in position to take on that office. But why? It's because someone probably took a screenshot or a picture of maybe a letter or information and shared it unlawfully. So we shouldn't be in that habit of, you have maybe particular project work before you that you have to evaluate, and you're taking pictures of. Before we know it, this information is available on social media, and people actually debating the same. So that goes to show you how important it is to secure the different personal data that we actually get to interact with a scope of work. Now, with the principles, we'll now look at the rights of the data subjects, what kinds of rights they actually have within the law. Now, the very first right is the right to be informed. And like I talked about the aspect of transparency, the principle of transparency, they need to be informed of who has their data, why is their data being collected, who may access the same, or who may it be shared with. For example, you may need to share, let's say if it is staff information, you may need to share it with NSSF for purposes of employee benefits, but they ideally need to be informed of the same. So that's right to be informed is actually one of the rights provided for within the law. Then, of course, the right to access their information. So if you're going about the scope of a particular project and somewhere along the way, one of the participants is requesting that they need to access their information, this is the right that they have and needs to ideally, you need to have procedures in place to exercise that right. And of course, it's important to note that this right can only be enjoyed by the data subject themselves, unless, of course, it's a matter of law enforcement where the police and other enforcement agencies need to access information. But if it's a data subject, I cannot ideally come and ask for information about another person. I can only request for my information. Then, of course, there is the right to rectification of data. We talked about the principle of quality, and you realize that all these feed one way or another feed into each other. So a data subject, a participant of a particular project should ideally have the right to correct or rectify the information in case it is inaccurate, or in case it has since changed, then there is need to have avenues in place within which they can rectify that information. Then there's also the right to prevent processing of personal data for direct marketing. Talked about the case of Shadia Naliwega versus Starbucks, where data is being used to market particular products. If you've had a very successful project implementation and you now want to, show the world that this is what has been done by our entity, that should be okay. But as you do the same, you need to ensure that before you use maybe people's pictures, you actually collect their consent to do the same and to use that information to market particular products. We've seen entities come out to do success stories. Before you record, someone's maybe footage and the kind, they need to inform them who may have access, where it may be shared, and what it's actually going to be used for in terms of marketing the success maybe of a particular project. Then, of course, the right to erasure of personal data, that data subjects can actually come before you and request that their data is actually deleted for particular reasons that they may have. But of course, it's important to note that these rights need to be enjoyed within the confines of the law. They're not absolute rights. For example, the right to erasure. I'll just give an example. We've actually had a case as PDPO on the same, which can be found online and on our website. The case of Philips Simba versus Cheaper Technologies, Uganda Limited, where this particular person requested for deletion of their personal data. But then the company had a particular legal obligation to keep financial information for at least 10 years, as provided for in the Financial Institutions Act. And of course, the data subject, the decision the office made is that yes, whereas you may have your right to delete your information, this can only be done after this period because there is that legal obligation the organization has to also comply with. So that goes to show that some of these rights are not actually absolute rights, but can only be enjoyed within particular confines of the law. But even then, before you deny someone their right, you need to have a lawful basis as to why you're actually doing the same. So if you have maybe a particular law you have to comply with, the anti-money laundering or any other acts, then in those circumstances, you'll find that some of these rights may be limited to that extent. Now you'll ask yourself, what are the offenses under the law? What happens anyway in case as a professional of M&E, I do not adhere to this law, I do not adhere to the principles. As an organization, we do not, implement some of these. What happens? We shall look at first what offenses are there within the law. The first being the failure to register with PDPO. I already talked about PDPO being the Personal Data Protection Office. So every data collector, data controller, or data processor is required to register with PDPO. This registration is done online on our website, and it is at a fee of 100,000 for every organization, or even individuals. We have individuals, some of them are registered with us. And this registration must be renewed annually. And of course, like I mentioned, everything else is done online, including that certificate of registration that we actually issue can still be accessed within the account you create with the office. Now, I don't know how many of us here are aware if indeed our entities are actually registered with PDPO. Because like you're seeing here, failure to register with PDPO is actually an offense within the law. And of course, prior to coming for this engagement, I tried to search our register, which again, I said is public facing for Uganda Evaluation Association. And unfortunately, I could not find it as one of the registered entities. But I want to believe that as an association, you collect personal data of your different members that are registered with you. And this is a call to action that before we come to crack the whip, you actually ensure that you register with PDPO. And this goes beyond just the association, but again, like I mentioned, for our different entities where we come from, ensure that you check and confirm if they're registered, and if they're not, encourage them to do the same, because we are going to look at the repercussions of non-registration of any of these offenses within the law. Then, of course, the other offense being the sale of personal data. You may realize that in this new age and era, personal data is like the new oil. And I think this is something that as M&E specialists and experts is something you can actually relate with, because we deal with a lot of data, we analyze a lot of data, which includes personal data. But you would find that, some entities actually may be in the habit of selling personal data or even buying the same. This is actually an offense within the law. The law does not allow selling of personal data. And I'll give you an example. I think for some people here, you may have probably bought something on the streets. You probably bought a snack, and you realize you're being given this particular snack. It may be someone's CV or someone's marriage certificate, or someone's medical results, and you can see all the medical information. But why? It's because maybe somewhere this information was either sold or misused, and that is why it's finding its place in that particular place. Then, of course, the other being unlawful destruction, deletion, concealment, or alteration of personal data. We talked about retention periods and how you can actually delete data upon expiry of that retention period. But you'll find yourself maybe in a scenario where personal data is being unlawfully destructed because, maybe law enforcement has come in and they need to look at particular records, which include personal data. But because you know that they're going to pin you and, catch up with you, you decide to destroy the same so that you're not caught. That ideally, that unlawful destruction or deletion of personal data is an offense. Then, of course, the other being unlawful obtaining or disclosing of personal data. This has two elements, both obtaining, where you may, let's say, buy data from other people, or where you may obtain information unlawfully, because you talked about the lawful basis for obtaining or collecting information. So we are doing any of the collection or processing outside the lawful basis provided for, that would ideally be unlawful. But beyond obtaining, even disclosing of the same, I think as an office in the recent past, we've been handling a number of cases, especially when it comes to the different mobile and digital lending applications, where we have people's data being collected. And at the point of them obtaining a loan from maybe an application, and when they default, you find that some of these applications actually go ahead and share their information, let's say on TikTok or any of the other social media platforms with their other contracts, you know, telling these people, hey, look here, this person is a defaulter, they're a thief, they're this, but this is beyond the purpose for which this information was actually collected. So that is actually an offense because it's unlawfully being disclosed. So as you go about, the different M&E work that we do, if you have data before you that you have to analyze, there is no need for you to disclose this information to someone who does not have the authority to have the same, because that would ideally amount to an offense. Then, of course, failure to comply with a notice issued by PDPO as an office, time after time, we do issue notices requiring particular entities to comply with the law. And where we have issued a notice and you do not comply with the same, that would ideally be an offense within the law. Then, of course, processing personal data in a country without adequate measures for its protection. We talked about the adequacy assessments that need to be done prior to transferring data outside Uganda, and indeed finding if these countries are adequate or not. So where you find that a country is inadequate, they don't even have a law in place, they don't have an office like we do have to enforce that law, and you still go ahead and transfer data there, then that would ideally amount to an offense. Then, of course, the other being processing of personal data without consent, where consent is required. We talked about consent being one of the lawful bases. So where you collect and process personal data and it requires you to obtain consent and you've not obtained the same, then that would ideally be an offense within the law. So besides the offenses, what happens when one commits any of these offenses? The first is that an entity can actually pay a fine of up to 2% of the institution's gross annual turnover. Now, I want us to look back at the different entities where we come from. I don't think any of us as M&E professionals would want to be the one responsible as to why our organizations are paying up to 2% of your gross annual turnover or your gross annual budget. And of course, 2% it's quite a huge amount when you look back at our budgets. For example, if it's for government would ideally be 2% of the budget. That is quite an amount. And I don't think any of us would want our entities paying this amount because we are failing to comply with the provisions of the law. Then, of course, the other penalty being imprisonment for between 3 months to 10 years, depending on the gravity of the offense, beyond the institution itself that you work for. As an M&E professional, if investigations are done by the office and the law enforcement agencies that you work with, and we indeed realize that you are the one who is responsible for disclosing information to any unauthorized party, then you can actually be imprisoned for up to 10 years. And this is not to scare you, but again, I don't think any of us here would want to be going to prison because we failed to protect the personal data that we analyze and we access as we go about our duties. This goes to show you that there is need to actually ensure that we adhere to the law and ensure that data that we work with is actually protected. Now, we'll talk about a bit about some of the court and PDPO decisions that have actually been passed, because again, someone else may ask, but has this law even been tested? Have we had scenarios where, this has been done? I already talked about the case of Shadi and Alubega, versus Starbucks International. And how, in this particular case, the pump attendant sued the employee for using her photograph, which was taken as she was going about her duties. And this photo was used to market products of Starbucks without her consent. So when she sued, court indeed agreed with her that this was a breach of her privacy and ordered the company to compensate her, and, which was done. But I don't think, of course, any of our organizations would want to be again in the news and before court because we fail to adhere to the principles and what the law provides for in terms of data protection and privacy. Then, of course, the other case being the one of Uganda versus Mogulu Ronald. What happened in this case is that Mr. Mogulu Ronald was accessed a particular loan application which he used to obtain money online. And before he could pay back the money, his information that he had used, his national ID, his photos, his contacts, were shared on a number of social media platforms, including TikTok. Letting the public know that this person is actually a defaulter, this person has failed to pay money, he's a thief, he's all sorts of things. But this was being done outside the confines of the law. And the company that was actually doing the same, which was Nano Loans Microfinance Limited, at the time was not even registered with PDPO, yet they were collecting and obtaining personal data. And this matter went to court. And of course, along the way, they pleaded guilty and they were required to pay a fine. They compensated the complainant, but also were required to pay a fine. Then, of course, the other being particular case that was investigated some time back by the office, where a border sharing application we have here in Uganda failed to inform its data subjects about sharing their data with a third party, which was an analytics firm in the US. And there was a particular company to analyze and help them confirm what times do clients usually use their application so that they can actually offer them discounts around that time. But this was being done and data subjects were not actually informed of the same. It was done without their consent. And as an office, we're able to direct that particular company to streamline the data processing activities and ensure that they actually comply with what the law provides for in terms of obtaining consent before sharing information outside Uganda and with third parties, but also informing data subjects on who may actually have access to the information. What are the benefits of compliance? Why do we need to comply with the Data Protection and Privacy Act and its regulations? One, of course, compliance is not just a matter of regulation. Yes, it is. It ensures adherence to regulatory requirements because that's what the law provides for. But beyond what the law provides for, there is need to improve our in-house data management practices. As we go ahead and ensure that data is secure, ensure that we inform data subjects before we share their data, ensure that we are accountable and responsible for the data we collect. This improves our data management practices within the organization, even as M&E professionals. But beyond that, it also builds customer trust and confidence. If I know that an organization A adheres to the law, is registered with the office, has procedures for obtaining consent, has particular security measures in place to protect my data, then I would be more inclined to go and share my data with them, even if it's a particular program where I have to benefit from, compared to sharing my data with an entity where I know that if I share my data today, the following day I'll find it on the streets being used to sell maybe a snack or something. So it builds that customer trust and confidence in our different organizations. And beyond that, it also prevents financial losses arising out of fines, litigation, and compensation. I talked about the cases, being sued because you failed to adhere to the law, the 2% fines that I talked about, even the costs of litigation when it comes to court. I don't think we'd want our entities to be in that back and forth. So if you comply with this law, it prevents some of these things from happening. Because to some entities, 2% of your gross annual turnover could even be up to, let's say, 1 billion shillings. And there's need you could use that money to even make your programs much better compared to using the same to pay fines and the kind. And beyond that, the other benefit is that it also averts imprisonment of staff. As M&E professionals, I talked about the fact that we can also be held liable where we are found to be in breach of the law, where we are the ones that caused the violation. We are the ones that shared information to unauthorized parties. Investigations have confirmed that we're the ones that sold this data to a particular company, then we can actually be in prison. But if we adhere and comply with the law, then some of these actually are avoided. It also safeguards data subjects, personal information from unauthorized access. We talked about how we need to be accountable and we need to be compliant, have these policies in place, have procedures in place to actually protect information that we collect and process. And beyond that, even the reputational damage itself. I don't think any of us wants our organizations to be out there known for being in breach of privacy and not protecting the personal data that they collect and process. That is not a reputation you want to have, especially given the fact that you've built your reputations over time. And of course, the last being that it creates that competitive advantage where you know that an organization X actually complies with this law, has these procedures in place to ensure compliance, is registered with the office, has these assessments done before they even share my information outside Uganda, then it will have that competitive advantage it gives you over the competitors within the same industry. And with those benefits, I'll also want to just share some best practices that we need to have as evaluators. What key takeaways do we need to have at the back of our minds? One, you need to ensure that your organizations actually institutionalize the data protection officer role. We talked about the fact that as you register with the office, you're required to designate someone within your organization to perform the task of a data protection officer. Now, this can be someone within the entity, or it can even be someone outside the entity. You could, if you have the means to, hire someone to just handle data protection matters, well and good. But if not, you can always get someone within the entity to perform the task. I know for a fact that we have a number of M&E professionals who are actually data protection officers for their organizations. For other entities, we have their legal departments, we have their IT officers as the data protection officer. But as an office, of course, we are also working, the guidelines I talked about. One of the areas we're also looking at is providing guidance on who can be appointed as a data protection officer. And this, of course, will go a long way in creating that clarity. Then, of course, always seeking informed consent from data subjects before you collect and process the data, ensuring that you've obtained their consent, where you need to actually use consent as a ground for processing their data. The other being accountability, ensuring that you're accountable to data subjects, be responsible for the data that you have before you. And even as an organization, we are able to test your accountability when you submit your annual compliance reports to the office. There's that obligation that beyond registration, there are a number of other compliance requirements you're supposed to have, including adherence to the principles talked about, but also filing annual compliance reports, which are filed at the end of every financial year. And that is from 1st July to 30th September. So in those reports, we're able to tell.
Briefly.
Yes, please.
We have only 30 minutes left to the top of our last hour. So if you could.
We have how many minutes?
We have some time left for Q&A. We have 30, okay, now 29 minutes left to the top of the second hour.
Okay, let me just conclude briefly. So beyond the registration in the office, there's also need to file those compliance reports where we're able to test your accountability to data subjects as you go about your duties. Then, of course, the consent notices that you need to have, for example, where you have events and you need to collect people's pictures, where you're using one of the other issues is also using devices like laptops. They need to manage privileged rights by ensuring that users can only access information they need while making assessments and analysis of the different information. And of course, including the others like encrypting data, having incident response plans in place, and training staff on a regular basis like we're doing here with this training is good practice for you as evaluators to ensure that you adhere to the law. Again, for the tips, you need to ensure that you are potential targets for cyber criminals. So there's need to ensure that you do not think that we are too small or too big to be attacked. Anyone can actually be a subject of cyber criminals. Then the passwords, ensuring that you don't share your passwords. We talked about how many of us may be sharing passwords with maybe friends or workmates, ensuring that you use free Wi-Fi with caution. For some of us, when you go to a new place, the first thing you're looking out for is a Wi-Fi password. But you need to be aware that some of these can actually be used to hack into your devices and actually obtain personal data from the same. Beware of phishing scams. We have a number of phishing scams these days, people being called for jobs in the UN and and the moment you click on it, you find that your information is actually gone because people can use that to access your gadgets, and there's need to ensure that staff are aware of the same. Having the antivirus and anti-malware protection on our different gadgets where we store personal data is also important. Ensuring that we don't leave our gadgets unattended to. If you're in office and you have to look at a particular report, you don't need to leave your gadget unattended because someone else can actually access information on the same. Then, of course, lastly, the two-factor and multi-factor authentication that can actually be enforced and used as a security measure to ensure that data is actually secure. Now, as I come to the end of the presentation, I just want you to have a look at this picture and tell me what comes to your mind when you look at this. What comes to your mind? Can I have maybe about 2 responses? Do you have anyone?
I think it would be helpful to first give context. What's this picture for? Because like this, it's very hard to provide any kind of information. Context would probably.
Okay, let me just give some sort of context. So we have done the awareness like we are doing here. Okay, we put in place the multi-factor authentication, the zero trust. We have our firewalls in place, and we are now headed in the right direction. But then we have someone who is holding, the door, and it looks like they're about to open it. So with that at the back of our minds, what comes to your mind when you look at this picture? What do you think?
Maybe to give my submission about that is that there are very many systems and things that have been put into place to ensure that the data is, well protected, but it is totally up to the user to choose how they can use whatever is put in place. Because ideally, if that user opens that door, then everything that is all these people actually that are in that vehicle are all going to fall down, and everything is going to power, and everything is going to look irrelevant, and the user is also going to be in trouble.
Okay, thank you so much, Kevin. And yes, that is indeed correct. That yes, you may have everything else in place. You have done the awareness, you have all this in place, but at the end of the day, it's just one person that lets you down. And for the IT specialists in the room, you know that it's usually said that the humans actually the weakest link when it comes to protection of data. So as users of these different systems, we need to ensure that, yes, we actually protect the information. It's a collective effort, because the moment this person actually pulls that, everything else we've put in place will actually fall down. So we need to work as a team to ensure that we protect the different information that we work with. And of course, as an office, PDPO, we are located on plot 32, Lumumba Avenue, on Padre Pio House. That's the 7th floor. And in case you need any information or you need any clarity, you can always reach out to us via email at info@pdpo.go.ug or any of those telephone contacts. And you can also visit our website. With that, I want to thank you so much for listening to me, and I can take on some questions now. Thank you.
Wow, thank you, Jordan. That has been very enlightening. And I'm certain every one of us has taken away a lesson or 2 or 3. There are quite a number of questions for you. The chat has been the busiest for a while. And then we have some questions in the Q&A. I'll begin with the Q&A section. We have a question from Matthew Lua. That is our past president. Mr. President, would you like to voice your question if you're still on call? I don't mean the political candidate, I mean the past president for Uganda Evaluation Association. Okay, let me quickly go through it. His question is, under qualitative analysis, we tend to capture voices, images of respondents, and include details of the individual in the reports. How is this affected by the PDPO law? I think that is the data protection. And if a client requires, in the terms of references, that personal data like names, phone numbers, NIN are captured and included in a report as evidence, who bears the liability? I think there are some other questions in line with that will be answered. Then the last one is, what are the fees for registering with PDPO? How many can you take on to respond? Can I do the 4th?
I think I can take on 3 at a time.
Okay, I've just read out 3, so you can respond to those, and then I'll read the others out.
Okay, thank you. So the aspects of having individuals, information, their names, and their voices being included in reports, and how this can actually be done. Of course, first and foremost, they need to be informed if at all the information is actually going to be used in those reports. At the point of collecting this information, they need to be informed of the same, so that they give that informed consent to go ahead and do the same. But 2, in the alternative, you could actually also pseudonymize or anonymize some of this information. For example, beyond just referring to someone by their name, you could maybe refer to them as maybe one of the participants, raised this, or one of the interviewees, sort of gave this kind of response. So pseudonymizing or anonymizing some of that will go a long way in protecting the identity of some of these individuals. Of course, unless they've given their explicit consent that you can include them in the report. Then the other question comes to where clients, want information being included in the report, and who bears the liability. Again, before you include that information in the report, there is need to obtain that consent from these individuals as you go about collecting or processing their data. When it comes to liability, there's what we call a data sharing agreement. When you look at our law under section 21, subsection 2, it provides that where you have to collect or process data on behalf of someone, there's need to have that contract, or what we call a data sharing agreement, in place. And this goes beyond just, detailing things of there's confidentiality and whatnot, but even speaks to aspects of liability where there is, for example, a breach. or where there's any misuse of data, that should ideally be captured within this report, depending, of course, on what measures are in place. As a data controller, you need to ensure that whoever you're sharing data with, in terms of processors that are going to do work on your behalf, actually have measures in place to protect that kind of information. So through that sort of contract, you can actually go ahead and enforce the same. Then on the fees that are paid to PDP, I think I had mentioned this earlier on, that the fees are 100,000 for registration with the office, as well as renewal. The fees still 100,000. Renewal is done after every year, and all this is done on our website. Thank you.
Okay, I will read another set of 3 questions. Is it possible to share the adequacy assessment tool for reference? This will be appreciated. Okay, the other is, I think, for UEA to share the slides. Yes, the slides will be shared on the fora. If you're not a member of Uganda Evaluation Association, kindly join. Go to our website, and all the details to becoming a member are there, and you'll enjoy other beautiful benefits for learning and collaboration like this. And okay, the second question for you, Jordan, is recently we applied for a data protection certificate and our firm was requested to pay 100,000. Why should organizations pay this fee, yet they are expected to be regulated? Maybe they seek clarity on that. The third is, where do limitation of purpose and time fall under the broad categories that were listed? Okay, we can take on those 3 and I will do another set of 3. I think there are additional questions that are coming in.
Maybe could you pardon me on the last question?
And the last one, they felt that the fee for 100,000 was not clear, so they needed clarity on why they are expected to pay the 100,000.
I think I only captured 2 questions, but in case I missed out the other, you can always take it on. I'll start with the question of sharing the adequacy assessment. Yes, that can be shared. You can reach out to us via compliance@pdpo.go.ug. I can just share the email in the chat that you can use to reach out to us for that assessment, and then it can be we can provide that template. When it comes to the payment of the 100 fees and 100,000, why you have to pay the same? One, first and foremost, this 100,000 is provided for within the law as the fees that you pay for application of this certificate. The same way you pay fees to, let's say, local council authorities like KCCA for a license, or the same way you pay for any other, let's say, the NGO bureau for that kind of permit, is the same way you actually pay this 100,000, because it's a matter of law provided for within the Act. But beyond the aspect of you being able to pay this registration fee, is that, of course, this is also another source of government revenue. It's something that government looks at as a way of obtaining revenue from the different entities that they collect and regulate. Because as we go about our duties, for example, a lot goes in as an office to enforce the law in terms of audits, in terms of assessments, in terms of inspections. A lot goes in to be in position to provide the same. So all that ideally would require finances to be in position to do the same. So that is the reason as to why some of these fees are there to facilitate some of the work that the office actually does. So that is why you're required to pay the 100,000. I hope that answers your question.
Okay, the next set of questions are mainly about consent and photos. The first one says, how do you handle consent for a group photo where many people appear in the photo? The same applies maybe to online meetings where someone needs to record the meeting, like such a meeting. How do you ensure that you obtain consent? The second question is, you talked about use of proper consent notice at events. What could be some of the methods? They give an example that they normally take pictures of people, including government and participants during functions, and they use them in presentations, reports, and others. So how can they go about notifying them and consent? The third is, are pictures taken at parties and in meetings without my consent a validation of the law? I will pause there for the three because it's mainly about consent and the photos. Over to you, Jordan.
Okay, consent seems to be taking center stage
Yes.
the discussion. Now, for consent, when it comes to meetings and group photos, for example, for meetings like this one, I noticed that at some point the meeting was actually recorded. But even prior to people joining the meeting or even registering for the meeting at the point of registration for this particular meeting, at the start of the meeting, it's always good practice to ideally inform them that this meeting may actually be recorded for purposes of, maybe accountability or for whatever reason as to why you may have as to why you may record the same. And of course, requesting people that are not comfortable being recorded, either to anonymize themselves or they can jump off the call or something like that. Because like I mentioned, that consent can be both oral and written. So it's not that you have to now look for each one on the call and ask them to write and sign off consent. It can be actually orally given. So that is how you can maybe manage it for meetings like this. When it comes to group photos, this is an example I've seen being practically implemented, where let's say you have an event or you have a conference and you have to take people's pictures, even throughout the entire session. We've seen registration forms where when someone is registering, they can actually tick yes or no, whether they consent to their pictures being taken throughout the event or not. And where one does not consent, then of course you can always inform whoever is in charge of taking the pictures that maybe the particular people seated in this corner, their pictures should not be taken because they do not consent to the same. That is something you can do practically for the group gatherings. And when it comes to them being used in presentations and reports, again, at the point of you either inviting people for an event, if you have to send out an email for an invitation, you can always inform them as an AOB that as a matter of practice, we may take pictures for this event. And if you're not comfortable, then you can always maybe inform whoever is at the registration tables or whoever is in charge so that they take note of that and in position to find a remedy to the same. And of course, this goes beyond just, at the point of collecting this consent, it goes beyond just letting people know that, you're going to take their pictures, but also informing them if these pictures may be used, for example, in reports or on social media to market the event or in things like that, or in a presentation. That can be something that you inform the different participants at the point of either registering for the event or even when they actually are there physically. When it comes to pictures, I think the question again was still around pictures and consent for like government, maybe programs or things like that. One key thing is what we call a privacy notice. And like we talked about the data protection policy, which is an internal document that speaks to the procedures and systems in place to protect data, which ideally binds the staff and any other third parties that you work with. Now we have what we call a privacy notice, which is now the external facing document. It is just a replica of the internal document, only that it is a bit more summarized and speaks to the general public that you work with on how you may collect or process the data. So this again speaks to the accountability principle, to the transparency principle. You inform them of how you collect the information, you may have access, how it may be used, and the kind. You can actually check out a number of these privacy notices on a number of websites. For example, if you check the NITA website, you'll find that there's a privacy notice. that speaks to how they collect or process information. So you can have it on the website. If it's an event, you can actually have it, maybe as someone is registering for the event, they can have it somewhere printed and pinned somewhere for them to see that as you come in, yes, this is the information you shall collect, including your photos, and can be used for ABCD, and whether they consent to the same or not. So at that point, someone is informed and is aware that whatever they're doing, they have actually been in position to consent to the same. So that's how you can go about it for the general public, where you don't have to obtain consent from each and everyone.
Okay, thank you. Enid Kaunga asks the question that I had also at the back of my mind. M&E professionals are increasingly using AI like ChatGPT for data analysis. What should we be aware of in terms of data protection? And the second question here is maybe about academia. How can PDPO support academia to protect students' data? And the third is, does the principle of length of retention of data apply to data sets that do not include personal information or personal data? I think please keep the questions coming in chat if there are any others. That's all that was in the chat and the Q&A section. Otherwise, feel free to raise your hand after Jordan has answered the last set of questions. Over to you, Jordan.
Thank you. So again, the issue of using AI for analysis of data, you've seen that, of course, artificial intelligence is growing over time, but also it poses a number of risks, especially privacy risks to the different individuals where we have data AI being used to analyze, personal data. One of the rights I didn't talk about is the right to, the right to prevent processing of personal data for automated decision taking is one of the rights that data subjects have within the law. So where you're going to maybe use AI and you've informed data subjects about the same, then they have a right to either withdraw from processing of their data or, say for but you need to be aware as some of these AI tools, of course, are a bit biased. Some of them will go ahead and pose a very high risk to this information because they actually store some of this data. Today you'll go in and put in data, and the next day they're using the data you put in last time to give you a response that is actually geared to what you're doing. So you need to tread carefully as you use some of these AI tools, because you'd find that you're going to include personal data that may actually be exposed, and before you know it, you have your institution in the gutters because of some of these issues. So we need to create a careful balance on sharing this kind of information in many of these AI tools. Then, of course, the other being PDPO and academia and how students can be supported. Now, first and foremost, we've been able to, in the past, we issued a notice requiring all schools to desist from publishing results of children when we have UNEB results being passed and the kind. And it's something which is now being implemented to ensure that, yes, they actually, because in the past we've had a number where you even find billboards of children's names, some even have their date of birth and what they scored and things like that. And even their pictures from which they can be identified. And together with the Ministry of Education, we're able to cap that in that way where we issued that notice. But going forward, we're also we've done a number of sensitizations in schools, but we're also in the process of working together with the Ministry of Education to ensure that all schools actually are registered with the office. The same way you see that for NGOs, for you to maybe obtain a license or permit from the NGO Bureau, you need to have a PDPO certificate. So that's something we're working together with together with the Ministry of Education, to have it for schools to ensure that schools are also complying with this particular law, because we understand they collect a lot of personal data of our children. Then, of course, the last question on retention periods and if this applies to the different other data sets. Like I mentioned at the beginning, that this law only applies to personal data. So where data is no longer personal data and cannot be used to identify someone, it has been anonymized and pseudonymized and the kind, it ceases to be personal data. So this law ceases to be in force. Maybe other laws may apply, but for the Data Protection and Privacy Act, it applies to personal data. So the retention periods may not apply to other data sets that may not include personal data, if that answers your question. Thank you.
Okay, thank you, Jaden. We have 3 minutes to the top of the hour. If you have a quick question that you feel has not been addressed in this discussion, kindly raise your hand. And okay, Betty, please unmute and
Thank you for organizing. Thank you, Uganda Evaluation Association, for having someone share this. I think it's very timely. We need to keep refreshing ourselves about some of these things. And for me, particularly, I've learned quite a lot. I had just an idea that, oh, as an organization, an institution, you need to register. And I didn't know that that had to be done annually. I also didn't know that you're supposed to file an annual report. So I think this just goes to show that there's still a lot of need for you guys to do a lot of sensitization out there, targeting the different audience or stakeholders so that we are all on the same board. I'd asked a question in the chat, which I think you didn't kind of tackle, so I will try and ask it again. When you were presenting the section on the principles of data protection, I think I saw about 7 or so, but I tried to listen keenly to those principles, and I didn't find where time and purpose fit, because I think as I try to draft a few policies for some institutions, we know that when you're collecting data for a particular reason, and beyond that, you shouldn't be doing it. And also maybe there's a time frame to that. Beyond that, you're not ideally allowed to use it beyond that. So I just wanted a bit of clarity to see where those two aspects fall in those broader categories. Finally, I have kind of a scenario that relates to one of the ideas you mentioned while you were presenting, the idea of when you're sharing data in another country, you kind of need to do an assessment to make sure, to kind of ascertain if the environment is going to be favorable and all of that. I haven't looked at what that assessment tool looks like, so I have no idea. But I'm just imagining majority, I believe, or many of us probably work with multi-country teams, organizations. Either you're working maybe for Plan International. Plan International probably has offices in different countries, and you might be having a project that actually the same project is being implemented in all of these countries. And maybe you have a database that sort of kind of collects information from your program participants, and everyone else from these different countries accesses this database. I just wanted a bit of clarity in terms of how do you actually practically implement that bit of what you said. When you're sharing data with other countries, you still need to do assessment. Just want to pick your thoughts on that. But other than that, I really appreciate this presentation. It's helped me to learn quite a number of things that I thought I knew, but I didn't know. So just appreciation, and thank you for organizing. Back to you.
Okay, thank you, Betsy. Let me just second that question. All those questions, I should
sorry,
say.
sorry. Just 10 seconds. While I joined, I think 2 minutes into 2, I noticed that people were writing names and details. I actually took the liberty to ask in the chat why we are writing that. I don't know if I missed that communication. And now that we're talking about data protection, I mean, somebody has to know why we are doing this registration and what is it for. I don't know if it's you going to take on that question, but if it's something that I haven't actually registered because I didn't get any clarification. If it needs me to register, once it's clarified, I can be able to share my details in the chat. Back to you.
Okay, I'll answer the last bit for Jordan. I am the one that posted the request. Maybe you logged in while the request had come just before. We usually request participants to share their contact and email addresses and where they work if they are comfortable, because Uganda Evaluation Association works with the evaluators from all fields, civil society and NGOs, government, private practitioners, and also because a number of our participants are usually interested in either the recording or the slides being shared, we usually use the email addresses to send out what has been shared in the presentation. So the request had been posted earlier, possibly before you logged in. Thank you. Over to you, Jordan.
Okay, thank you. I'm glad that people are already asking questions as a result of this. That goes to show that these people are appreciating this particular engagement. Now, I'll just speak to the aspect of sensitization. Yes, we also noticed that is something we need to do. And as an office, we are deliberately taking steps to ensure that we have everyone else on board. For the aspects of where the principle of purpose limitation falls, just to answer Betty's question. Now you'd find that in a number of different laws, you go to Kenya's law, you go to GDPR, you go to South Africa's law, you find that a number of these things are really cross-cutting. What changes is really either the English, but the laws are almost similar. So in other laws, you'll find it being called purpose limitation as a principle, whereas in ours, we find it being called the principle of relevance, meaning data minimization that I earlier talked about, that you should only collect information for a particular purpose and a relevant purpose and limited to that purpose. That's how the whole concept of data minimization and relevance comes in. So it's really more or less the same as the principle of purpose limitation that you may have in other laws. Then, of course, the other being on retention, on time, on how you cannot collect or process data beyond a particular time. It talks about that. That speaks into the principle of retention, that, this information should not be collected or retained within a particular period of time. And beyond that, then it would be ideally unlawful to do the same. For the other question on the assessments and how this can be done, well, first and foremost, of course, like I mentioned, that for Uganda's case, the only way you can transfer data outside Uganda is conducting that adequacy assessment or consent of the data subject. But in other countries, and of course, our law, unfortunately, did not, at the time of it being drafted, did not consider some of the scenarios like you've given of Plan International, where you have it in Uganda, in Kenya, and maybe in other countries, and how they're sharing data across the different branches in these countries. In other laws like the GDPR, like the Kenyan Data Protection Act, like South Africa's Act, this is provided for as one of the measures within which data can be transferred outside those countries. And there's something they call the binding corporate rules, where entities in the same group, or in the same conglomerate, can actually share data across each other, as long as they have those binding corporate rules which have been approved by the data protection authorities in those countries, and they would not need to ideally make these assessments whenever they're sharing data across those branches. But also something we are looking at doing, which we also have the powers to do is to do with what we call the white list of adequacy decisions. As an office, we are mandated to come up with a list of countries that we find are compliant with data protection and privacy. And once we publish and gazette that list of countries, then you will not need to conduct this kind of assessment if you're transferring data to those countries. But as of now, that list is still a work in progress. But once it has been publicized and gazetted, as the law requires, then some of these will be cured. But for now, we can only implement it as is. Thank you.
Okay, thank you. Thank you, everyone. I don't see any other hands. I think all the responses have been satisfactory. I can't thank you enough, Jordan Magala, and the team at the PDPO office. I think we should have these more frequent so that we can enlighten all the practitioners and maybe the institutions in turn. Please pass on my gratitude from the Uganda Evaluation Association and the members. And to the participants of the day, thank you for coming in large numbers. It has been a pleasure learning and unlearning with you. And please subscribe to the Uganda Evaluation Association because that's where all the learning of the good things are happening. I wish you all a wonderful afternoon, rest of the afternoon, and thank you all once again for participating and Jordan for taking us through this beautiful session of learning. I have put my email address for individuals who would like to join Uganda Evaluation Association or have additional questions in chat. And also, I'm assuming that those who shared their email addresses have consented, and we will work to share the recording with you. Unfortunately, there was a glitch. I think when I lost my connection, it stopped recording. That hopefully, Jordan, you'll be kind enough to also share with us the slides so that we can disseminate them to our participants. Thank you once again, and may God bless you all. This is the end to our national evaluation talk. Bye-bye.